Hello viewers, today we will discuss the topic copyright issue in digital medium. Copyright is about protecting original expression. Copyright protects original work of authorship that are fixed in any tangible medium of expression from which they can be perceived, reproduced or otherwise communicated either directly or with the aid of machine or device. Copyright arises as soon as a work is created. It does not extend to any idea, procedure, process, system, method of operation, concept, principle of discovery unless fixed in a tangible form. Copyrightable works includes the following categories: literary works, musical works, including any accompanying music, choreographic work, pictorial graphic works, motion pictures and audio-visual works, sound recording, architectural works and computer programs. In a digital medium, every web page accessible or published in the World Wide Web is to be taken as literary copyright work. It protects all written text materials, graphic, images, designs, drawings, any linked sound, video files or films, whether part of a web page or a website. That is, copyright protects the look and feel of a website. Copyright in digital medium, we will briefly discuss it now. Technology is a double-edged sword. On one hand, it is creating new means to fix the original expression in a tangible form, and on the other hand, it is being exploited in infringing the copyrights with impunity. Even some of the internet activities like caching, browsing, mirroring, scanning, downloading, uploading or file swappings are anathema to purists. First, we will discuss what does caching mean. Caching, it is used to improve response to time for end users. It means copying of a web page site and storing that copy for the purpose of speeding up subsequent accesses. Then browsing, software driven process for searching the World Wide Web using a browser. Mirroring, it improves service for the use by reflecting a website across various servers all over the world and make available the critical information to all the users at all times. Then downloading, it means to receive information, typically a file from another computer via modem. Then uploading, it means to send information, typically a file from another computer via modem. Then file swapping, a peer-to-peer transmission of digital files from one computer to another via the internet. Then scanning, when we scan an image, we reproduce it in an electronic or digital form. With the digital version, we can then do many things, including store and retrieve the image to and from a digital storage disk, edit it in software programs like Photoshop and compress it for web broadcast. Therefore, scanning is a process of reproducing any data or image in electronic or digital form. It is important to note that these internet activities like caching, browsing, mirroring, scanning, uploading, downloading or file swapping may result in the infringement of the exclusive statutory rights of a copyright owner through the following ways. The very first one is transmission of copyright work from one computer system or network to another involving temporary storage, that is considered as a RAM of that information. Another one is an unauthorized storage of the copyright work resulting in violation of the copyright owner's exclusive right to make copies. There is to reproduce the copyrighted work. Then distributing the copyright work to public, thus violating copyright owner's exclusive right of distribution. An appearance of a copyright image in a web browser, thus infringing the copyright owner's right of public display. Another one is preparing derivative works, thus infringing copyright owner's exclusive right to prepare derivative works. The question is whether such activities really infringe the 5 exclusive statutory rights of a copyright owner, such as to fix the information in tangible form, to reproduce the copyrighted work, to sell, rent, lease or otherwise distribute copies of the copyright work to the public, to perform and display publicly the copyright work, to prepare derivative works based on the copyright work. The answer is yes. Internet activities like caching, browsing, mirroring, scanning, uploading, downloading or file swapping may result in transmission of information from one computer system or network to another, involving temporary storage of that information. An unauthorized storage of such information, a violation of the copyright owner's exclusive right to make copies, there is to reproduce the copyrighted work. A violation of the copyright owner's exclusive distribution right. An appearance of copyright's image in web browser, infringing the copyright owner's public display right. Another one is an infringement of copyright owner's exclusive right to prepare derivative works, that is prima facie the nature and characteristics of internet activity is such that there will be certainly be infringement to the exclusive statutory rights of the copyright owner. In the backdrop of aforesaid discussion, it is significant to note that both the lawmakers and the adjudicators have started appreciating the limitations of the existing copyright laws to regulate activities emerging from the use of internet. Infringement of copyright by various internet activities. Now, we will discuss that above mentioned internet activities infringe the following exclusive statutory rights of the copyright owner. The very first one is right to reproduce the copyright work. Another is right to fix the information in tangible form. Next is right to sell, rent, lease or otherwise distribute copies of the copyright work to the public. Then right to perform and display publicly the copyright work. Then right to prepare derivative work based on the copyrighted work. It is significant to note that both under international and national law efforts are made to protect the copyright in digital medium and to prevent the infringement of copyright in digital medium, digital downloads. Assessing the internet needs software support in the form of browser like Internet Explorer or Netscape Navigator. A browser help in downloading website, web page, software, music, streaming video or movie from the web. It facilitates digital download. One may save such downloads in the computer's hard disk or in the removable storage devices. It amounts to fixation of digital downloads in a tangible form. Now we will discuss digital downloads and RAM. These digital downloads are also the part of the memory called random access memory, or you can consider it as a RAM. It is a volatile and needs a constant supply of power. When a computer is turned off, everything in RAM disappears. In other words, digital downloads are temporarily stored in a RAM. In a case of Apple Computer versus Formula International, it was held that copies stored in the random access memory were temporary and running a computer program from RAM does not create an infringed copy. Then we will discuss digital downloads and reproductive rights. The reproduction and display of copyright work of another person in a non-removable, for example, hard disk of a computer, web server, etc., or a removable storage medium without his authorization amounts to an infringement of statutory right vested in said copyright owner, digital downloads and distribution rights. Distributing and display copyright work of another without his authorization amounts to an infringement of statutory exclusive right vested in the said copyright owner. In the case of Marboy versus National Association in the Fire Acube Distributors, the court held that the act of placing unauthorized copies of Plaintiff's electronic clip art files on the defendant's web page constitute an infringement of distribution rights of the plaintiff, as the plaintiff's file became available for downloading by internet users. Then we will discuss digital downloads and display right. As evident from the aforesaid discussion that whether it is the infringement of reproduction rights or distribution rights, the display right of copyright owner is also equally affected. When a person views a page of a website using his browser, it seems clear that a display has occurred. Now the question is, from the point of the copyright law, who should be deemed to be responsible for the display? The viewer for the pointing his browser at a particular web address, or the website owner for making material available for display, or both? The idea is to see who is the publisher and who is the user. Web pages are displayed at the request of the user's browser. Display is akin to publication. When a browser requests a website or a web page, the request is executed by first searching and then connecting to the said website or web page. The request is executed by first searching and then connecting to the said website or web page. Once a connection is established, the said website or web page is downloaded for the viewing on the computer system or network. In such a scenario, the website owner is deemed to be the owner of a copyright material which has been downloaded from the web server. Any subsequent act of publication, transmission or storage of downloaded information in an unauthorized manner by any other person will amount to infringement of display right of the website owner, who is also deemed to be the owner of copyright material. Then we will discuss derivative works. A copyright owner has an exclusive right to prepare derivative works based on his original presentation. The Copyright Act of US defines derivative work as a work based upon one or more pre-existing work, such as translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation or any other form in which a work may be recast, transformed or adopted. Therefore, any attempt to create the similar look and feel of a copyrighted work would amount to an infringement. Copyrights in digital goods. Now we will discuss this term. Computer software is a digital good. One can either download it from the internet or purchased licensed software embedded in removable magnetic or optical storage medium. The phrase computer software is commonly used to describe computer programs and ancillary materials. From the point of copyright, computer programs are literary work, constituents of computer software. It is obligatory that one may have to consider computer software as a collection of items and materials associated with the development and operation of the computer program, but which does not include computer hardware. It may include: the first is preparatory design material like flowchart, diagrams, written specification, form and report layout, design for screen display, etc. Another one is computer programs and other executable code. Then software development tools like relational database development system, compiler, report generator, etc., database and data files, computer output, for example sound, printout, computer file or data, electronic signals, etc. Then screen displays, manual and guides, programmed language. It is obligatory to note that written specification, flow charts, form and report layouts, designs for screen displays and computer outputs like sound, printout, etc. all are protected by copyrighted, provided they were original in the copyright science at the first instance. Then we will discuss computer program as a literary work. A computer program is a copyrightable literary work per se. Like any other literary work, a computer program has an expression of its own. That expression is in the form of an application with a front end and back end. The front end, which is visible to the user, consists of screen displays, symbols, design layouts, commands, menu systems, other non-literature elements, etc. Whereas the back end consists of object code and source code and other executable code. These codes encrypt the computer program. Any recompilation of disassembly of object code or source code may amount to decryption of the said computer program. For the purpose of the copyright, both front and back end expressions are copyrightable, with an exception that process of decryption of computer programs may not infringe the relevant copyrights. Then we will discuss copyright in the digital medium, specifically an Indian perspective. It was in 1994 that for the first time the Copyright Act 1957 had gone for a digital makeover by including computer programs as a literary work. Section 2(o), it is important to note that section 2(FFC) defines the term computer program as a set of instructions expressed in words, codes, schemes or in any other form, including a machine readable medium capable of causing a computer to perform a particular task to achieve a particular result. Then copyright in a computer programs. The Act provides a very comprehensive definition of a computer program. It may include the following copyright material. First is preparatory design material like flow chart, diagram, written specification form, report layout, design for the display, etc. Then computer programs, object and source code and other executable code. Then software development tools like relational database, developmental system, compilers, report generators, etc. Database and data files, computer output, for example sound, printout, computer file or data electronic signals, screen displays, manuals and guides on paper or stored digitally. Programmed language, it is obligatory to note that written specification, flowchart form and report layout designs for screen display and computer output like sound, printout, etc. all are protected by the copyright, provided they were original in the copyright science at the first instance. Then we will discuss source code and object code. The computer program, whether written in assembly language or high level language, is known as the source code. When the source code is translated by an assembler or compiler into machine language, it is known as the object code. Thus, the object code is represented by strings of zeros and ones of binary number system and hexadecimal notations of the electrical charges. The object code cannot be seen, touched or heard, but there can be no doubt that it exists. The question is, would the object code existing in intangible form be referred to as a literary work and hence be protected under the copyright laws? In one of the earlier judgments, Data Cache System Inclusive versus JS&A Group, the court held that program was not protected by copyright as it was not in the form in which it could be seen and read with the naked eye. Later decision overruled this position in Sega Enterprises Limited versus Richard. It was held holding that the copyright subsists in the assembly code version of the program and that the object code was either a reproduction of or an adaptation of the assembly code version, and as a result the object code was also protected by the copyright. Similarly, in Apple Computer versus Franklin Computer Corporation, the court was of the view that the object code was subject to the copyright protection. Thus, the bottom line is that prima facie copyright law applies to both source code and object code, and the owners of the copyright in the computer programs are in fact copyright holders to both source code and object code. Then we will discuss copyright in a computer database. A database is a collection of data that is organized so that its content can easily be accessed, managed and updated. However, under Article 5 of the WIPO Copyright Treaty 1996, compilation of data or other material in any form which by reasons of the selection or arrangement of their contents constitute intellectual creations are protected as such. This protection does not extend to the data or the material itself and is without prejudice to any copyright subsisting in the data or the material contained in the compilation. Further, Article 1 subclause 2 of Chapter 1 of Directives 96/9 EC database is a collection of independent works, data or other materials arranged in a systematic or methodological way and individually accessible by electronic or other means. Article 10 subclause 2 of Section 1 of TRIPS Agreement, compilation of data or other material whether in machine readable or other form which by reasons of the selection or arrangement of their content constitute intellectual creation shall be protected as such. Such protection which shall not extend to the data or material itself shall be without prejudice to any copyright subsisting in the data or material itself. Then we will discuss copyright in computer database Indian perspective. In India, under the Copyright Act 1957, the scope of the term literary work had been broadened by amending Section 2(o) in 1995 by the Copyright Amendment Act 1994, so as to include computer programs, tables, compilations including computer databases. Therefore, the Act brings computer database within the definition of literary work and would therefore provide the same protection as would be available in the literary work. Then we will discuss some measures of the protection. The technology has provided very valuable method to the author or owner to protect his copyright work in digital form. One such method is encryption technology, where plain text legible form is converted into the capture text, that is illegible form, and the only author or owner or authorized person could decrypt such capture text into the plain text. However, technology is not completely foolproof but could be violated. Therefore, there must be legal protection against violation of technology measures. It is important to note that under the international law, legal protection against violation of technology measure is provided under WCT 1996 and WPPT 1996, violation of technology measures Indian perspective. Regarding Indian law relating to the violation of technology measures for protection through adequate legal protection as provided under the WCT 1996 and WPPT 1996 was not provided earlier under the Copyright Act 1957. Still, there were some provisions which were considered to be applicable in such cases. However, the Copyright Amendment Act 2012 has brought tremendous change in this regard, as Section 65A has been incorporated. Section 65 defines protection of technology measures. It criminalizes the violation of an effective technological protection measures which has been applied for the purpose of protecting any of the rights conferred by the copyright statute if the violation is performed with the intention of infringing rights conferred by the Act, unless it is carried out in one of many circumstances in which the Act states that violation is permissible, such as for conducting any lawful investigation or taking measures necessary in the interest of national security. Then we will discuss online copyright infringement. It is important to note that infringement occurs when either the whole or a substantial part of the author's right relating to his creative work are used by another person without his authorization. Significantly, there are different classifications of online infringement. According to the first classification, copyright infringement is of three types. The first one is direct infringement, then contributory infringement, then vicarious infringement. Copyright and reverse engineering in a computer software and Indian perspective, it is important to note that Indian law, there is section 52 subclause 1 of the Copyright Act 1957 also permits reverse engineering in computer software, though for the limited purpose therefore does not consider it as a copyright infringement. Basically, section 52 subclause 1 is a fair use clause and mention various acts which do not constitute an infringement of copyright. However, important clause related to computer programs are any act necessary to obtain information essentially for operating interoperability, section 52 subclause 1ab, the doing of any act necessary to obtain information essential for operating interoperability of an independently created computer program with other program by a lawful professor or a computer program, provided that such information is not otherwise readily available. The observation, study or test of functioning of the computer program, section 52 subclause 1ac, in order to determine the ideas and principle which underlines any elements of programs while performing such acts necessary for the function of which the computer program was supplied. Therefore, reverse engineering in computer software is permitted under Indian law, and any new program created by reverse engineering is copyrightable, provided it is expressed in different form. However, making unauthorized copies of existing computer programs and hence infringement of copyright and programmer. In concluding remarks, we can say in India the Copyright Act 1957 grants protection to original expression, and computer software is granted protection as a copyright unless it leads to a technical effect and is not a computer program per se. The computer software which has a technical effect is patentable under Indian Patent Act 1970. Generally, computer software which does not have a technical effect is protected under copyright law. For purpose of copyright protection, computer software needs to be original and sufficient effort and skill must be put into impart it originally. But a program which only generates multiplication tables and a logarithm may not suffice the degree of effort required for protection. Apart from being the original, not copied from elsewhere, the work should be first published in India, or if the work is published outside the India, the author on the date of publication, or if the work is published outside the India, the author on the date of publication is dead at the time of his death, should be the citizen of India. Thank you viewers for watching these programs.